Hello and welcome to the second in the AI webinar series run by the Silicon Valley office of Fieldfisher. And today you've got the usual cast of myself, Felicity. I'm a partner based out here in the Silicon Valley office, and I'm joined again by Richard Lawn, my colleague who's also based out here with me in the States. For those of you who've been following our AR webinar series, you might have listened in to the first in the series where we talked about the issues around identifying whether you're a controller or processor. And that analysis is really important for the background context to today's session, which is going to be around establishing your legal grounds to process data. And the controller processor analysis is relevant to this discussion because only controllers have to identify a lawful basis for processing. And so today, Richard and I are going to walk you through some of the issues to consider when you're trying to select your lawful grounds. Just some housekeeping before we get into this. The webinar, like all of our other webinars, will be available to view on our YouTube channel. So there's Fieldfisher Silicon Valley, we have our own YouTube channel, and you can view this webinar and previous webinars that we've done on that channel. And then just to keep an eye out, because the third episode of this series, which we'll be doing live, is going to be done by a couple of our other colleagues. So if you're bored of hearing Richard and I speak about artificial intelligence, we're going to change it up and have two of our other colleagues running a session on ethics and explainability on the 29th of April. So look out for that. And then for all attendees, we're also going to follow up by sending you a copy of the slides via email this time. We had lots of people last time asking, can we have a copy of the slides? Can we have a copy of the recording? Don't worry, if you've attended, we'll send you a follow-up email with all of the details. So just to provide a little bit more context here before Richard digs into the details. The different phases of AI development to deployment to improvement of the models all involve processing data for very different purposes and in quite different ways. And the GDPR tells us that for each of those different purposes, when we're acting as a controller and processing personal data, we need to identify a lawful basis under Article 6 of the GDPR. And there are a number of different legal grounds or lawful bases which you can rely on. But the important point to note is that you will need to identify a lawful basis for each of the different purposes for which you're processing data. And this becomes quite interesting in the context of AI development and deployment, because often old data may be being reused to generate new data insights and inferences using AI data models. And so what can often arise is that data which you were previously, you may have been relying on a particular legal ground to process the data, suddenly you need to reevaluate whether or not that legal ground can be used for the new purposes for which you may be processing data. And to give you a bit of an example, AI may be used to train a general model that's used for general purpose tasks. So let's think about an example like facial recognition technology, which may be designed to recognize faces. But that functionality may be used in quite different contexts for multiple different purposes. The prevention of crime, maybe authentication purposes, or even just tagging people on social media sites like Facebook. And for each of those different purposes, you might have to think about very different legal grounds to support that processing. At the same time, whilst you do have generally as a starting point flexibility to identify what legal ground you want to rely on, sometimes the law will force a particular legal ground because there may be a requirement in either the GDPR or another legislative framework that forces you to rely on, for example, consent to process personal data for the particular purpose you're trying to use the data for. And we'll talk a little bit more about when the law forces consent in this session too. So with that said, over to Richard to kickstart things.
Great, thanks Flick. So as Flick is set up, if you're a controller of personal data, you have to have a valid lawful basis in order to process the data. This is a really fundamental requirement under the GDPR, And it not only informs some of those obligations you're going to have as a controller under the GDPR, but it's also a keystone in establishing that your processing of the data is fair and lawful. So what does this involve? Well, you have to identify your lawful basis before you begin processing, and you shouldn't be switching to a different lawful basis later on. And you should also document that lawful basis. It has to be specified in your Article 30 data processing records, and you may also need to complete some more thorough legal analysis of which lawful basis you're relying on. And then you also have to explain what lawful basis you're relying on to the data subjects themselves in your privacy notices. And that's equally important so that data subjects can understand how your processing is lawful, and because that basis might also have a direct bearing on what rights are available to them as well. So far, so good, but there is this slight curveball in that certain types of data and certain methods of data collection are going to require extra attention. And what we're talking about here are those consent requirements that mean that you have to obtain consent from the data subject either to collect or process their data, and how that consent requirement impacts your basis under the GDPR. And that's something that Flick's going to talk about a little bit later on. But to begin with, we're going to explore the different lawful bases under the GDPR and which are going to be most applicable in the context of AI. So under Article 6 of the GDPR, there are 6 lawful bases, 6 for 6. But what we're really most interested in are these 3 up at the top of the screen: performance of a contract, consent, and legitimate interests. And these are going to be the most relevant in generally speaking, for AI commercial contexts. But before we consider those 3 grounds, there's a really important rule that we have to remember, and that is that context is king, or even better, context is queen. And what I mean by that is that it's not necessarily the data itself that is going to determine your lawful basis for processing. Rather, your basis is going to be tied to the context in which you process that data, or more accurately, the purpose for which you're processing the data. So you may be using the same data for multiple different purposes, and you need to have a lawful basis for each of those purposes. It could be the same lawful basis, or it could be different depending on the context. So let's take an example. Let's say we're building a facial recognition model. This is going to be a really advanced and sophisticated model that stands out from the market. Now, when we're building that model, we may need to process personal data to design the model, to train the model, and for model selection. And during that development phase, we're obviously going to need to identify what's our lawful basis to do that. And then we're going to come to deploy the model. And because it's so advanced and sophisticated, there may be a variety of different uses for that model. So for example, the model might be used to so that you can tag your friends as part of a social media platform. So that Where's Waldo exercise of identifying Waldo from a very crowded pre-pandemic photo, that wedding back in 2019, and it helps you to tag Waldo in the photo. Or maybe actually Waldo's using the model for authentication when he's logging into his application or platform, and the model is equally helpful there. Or perhaps it turns out that Waldo isn't a great guy after all, and the model is being used as part of a CCTV network to identify crime, and it can identify Waldo through the CCTV footage. So obviously all of those different use cases are quite different, and they might rely on different lawful grounds, they might rely on the same, but the point here is that there needs to be a separate analysis for each of those use cases. And then finally, you're probably going to want to retrain the model so that you can continue to improve it. And for that improvement purpose, you're also going to need to identify your lawful basis there as well. So that being said, we can turn to looking at these 3 bases in a bit more detail. Now we're going to assume that you're familiar with the basics here, but essentially we have performance of a contract. That's where processing is necessary to perform a contract with the data subject, i.e. to provide a service to them. We also have consent, which is where the data subject has given their GDPR standard level of consent to the processing. And we also have legitimate interests, which is where you as the controller have identified either your own or a third party's legitimate interests to process the data, and those interests are not overridden by the rights and the interests of the data subject themselves. Now, perhaps usefully, we can consider performance of a contract and consent separately to legitimate interests. And the reason for this is because both of these two bases are likely to have a much narrower application in the context of AI. And there are numerous reasons for this. So one of them is that probably they're both going to involve a direct relationship with the data subject. For performance of a contract, that's definitely the case because the controller needs to process the data to perform a contract that the controller has with the data subject. So they're providing a service directly. And for consent, it's usually also going to be the case because it's much easier to obtain consent if you have that direct relationship. It's not always going to be the case. You might be able to rely on another controller to obtain that consent on your behalf. So for instance, your customer that has a direct relationship with the end user, but that involves a number of challenges, not least because can you ensure that that third party obtained consent meets the GDPR strict standards? And is it also commercially feasible to require your customer to obtain consent on your behalf? But putting that question aside for now, there are other reasons why these two bases are also more narrow in their application. So performance of a contract is very narrowly interpreted. So that means that objectively speaking, is the processing necessary, strictly necessary to achieve what you're trying to achieve under that contract and to provide the service. And this is really narrowly interpreted, and to just illustrate that, we can consider the EDPB's guidelines on the performance of a contract ground in the context of online services. And those guidelines provide a number of examples where the ground is not going to be available. So one is where a controller is carrying out monitoring and profiling for fraud prevention. Here, the EDPB says, well, that's a very useful processing purpose and it's helpful, but it's likely to go beyond what's objectively necessary to perform the contract, and therefore this ground is unlikely to apply. Another example that the EDPB gives is an online travel search engine that creates a profile of a user based on their previous search history and bookings, and it makes recommendations based on that. And again, here, even though that's a very useful feature, the EDPB says it's still not objectively necessary to provide the core service and perform the contract. And therefore, again, the ground is unlikely to apply. And that may leave you thinking, well, when is performance of a contract going to be relevant? And unhelpfully, the EDPB doesn't give any positive examples, but one example might be a digital shopping assistant that's core purpose is to provide recommendations based on your shopping habits and previous purchases. So for instance, an assistant then can say, well, it looks like you really like Lululemon, so perhaps you should also try out Athletica or Sweaty Betty or something like that. So there, again, it's a core aspect of the service and it's intrinsically linked. Now, consent also has some challenges as well. So as mentioned, there's a very strict standard under the GDPR to obtain that consent. It has to be freely given, specific, informed, and unambiguous. And in the context of AI, if you're carrying out complicated processing operations, or if you're seeking to use the data for multiple different purposes, then it can be difficult to ensure that the consent is specific and informed, and therefore you're obtaining that valid consent. And lastly, there's also an issue with these two bases because they're of limited duration. So clearly, performance of a contract isn't going to be supporting any processing beyond the lifespan of the contract. If the account or the contract is terminated, then you can no longer rely on that ground. And also for consent, a data subject can withdraw their consent at any time, which means that at any moment you are no longer going to be able to process the data and you have to stop. So for all of these reasons, these two grounds have a narrower application for AI. And where does that leave us? Well, it leaves us with legitimate interests, which is probably the ground that you're already relying on, or perhaps the one that you are considering. And that's seen as a lot broader than the other two grounds. It doesn't require or imply a direct relationship with the data subject, and it's also envisages far broader use cases that are not necessarily tied to providing the service. So for the remainder of today's session, we're going to be focusing on this ground and how you can help establish your legitimate interests as your lawful basis. So how do you go about doing this? Well, breaking it down at a very high level, this consists of a three-part test, and this is the legal test to ensure that you have those legitimate interests. The first part of the test is what's called the purpose test. And this is really just identifying what your lawful and legitimate interest is in processing the data. What's the purpose here? And again, going back to what we were talking about earlier, that has to be identified on a purpose level. So just clearly separating your different purposes. The second part of the test is the necessity test. So you have to be able to demonstrate that the processing is necessary to achieve that purpose. Does it actually further the interest you're pursuing? Is it a reasonable way to go about it? Or are there any less intrusive means by which you could achieve the same result? Now, on the basis that you can satisfy that part of the test, we move on to the final part, which is the balancing test. And this is really the most important and perhaps most complex part of legitimate interests. Here, you have to establish that the interests you've identified are not overridden by the rights and freedoms of the data subject. And it's showing that basically your interests are balancing against any potential impact or intrusion on the data subject's rights. And that involves considering a whole bunch of principles and obligations under the GDPR and beyond to ensure that your processing is fair. And obviously this becomes particularly relevant in the context of AI, where there may be very complicated processing carried out, and there could potentially be use cases that have a direct impact on the data subject's rights. So I'll now hand over to Flick, who will be talking about the balancing test a little bit more.
Thanks, Richard. Yeah, so as Richard has just sort of outlined, relying on your legitimate interests is a more flexible basis on which to process personal data, but it comes with additional accountability obligations that essentially require you to assess the impact of your processing on the individuals, and also to be able to demonstrate that there is effectively a compelling benefit to the processing. So it's not a cure-all tick box legal ground. It's not something you can just select and move on. The expectation is that you have, followed this three-part test and documented that in a legitimate interest assessment. Now, the GDPR doesn't ever talk about legitimate interest assessments, but the natural outcome of having to think about all these issues is that it makes sense to document that in a risk assessment or a legitimate interest assessment, and to maintain that in your kind of bank of accountability documents. So with that said, how do you actually think about this balancing test? Well, as Richard has just hinted at, really the balancing test is asking you to take account of the interests or fundamental rights and freedoms of the data subject, and to check that they don't override your own interests. So in essence, again, we're really talking about a light touch risk assessment to check that any risks to the individual's interests are proportionate. And in doing this, we're really also running up against this, the GDPR principle of fairness, which is set out in Article 5(1)(a). And that really requires you to think about whether the processing of personal data is done in accordance with the reasonable expectations of the individuals. It also requires you to implement measures to do things like prevent the arbitrary discriminatory treatment of individuals, and also to think about whether or not the data that you're using is really data that is necessary for the purposes that you're collecting it. And I think it's also worth thinking about the definition of fairness that's recently been published in the EDPB guidance on data protection by design and default, because I think it's particularly relevant in the context of AI. Because it says fairness is the overarching principle which requires that that personal data shall not be processed in a way that is detrimental, discriminatory, unexpected, or misleading to the data subject. So really, again, asking you to think about the likely impact of your use of AI on the individuals, and importantly, to continually reassess that. And in particular, fairness requires, in the context of AI development and deployment, that the systems do not produce any bias, because obviously bias can lead to indirect or even direct prejudice and discrimination. So the question of whether the output of AI is fair is really linked to whether you can explain the decision making behind it. You need to be able to actively account for and justify why an algorithm is fair, and why the chosen use of that algorithm doesn't lead to inappropriate results. So really kind of drilling down and ensuring that when you've developed your model and you've developed your algorithms, that you've done so in a way that ensures that you're not, producing outputs or decisions that are discriminatory in any way. So when you were selecting data at the training phase, did you make sure that you had representative data, that it was accurate? If you're, doing any tagging of data to support the development of your models, were the tags done accurately? And again, to make sure that you've got a, representative body of data that's been used to train the models. And, there's a nod to this in the GDPR, because it talks about, one of the measures that you should think about having in place to prevent this kind of discriminatory outcomes are mathematical and statistical procedures. So really thinking about what you've done to interrogate the outcomes of the models, checking what data inputs are going in, and really making sure that you've properly tested those models before it's rolled out to the deployment phase. And it's also important to bear in mind here that when we're thinking about whether or not the processing kind of impacts the rights and freedoms of the individuals, the GDPR takes an extremely broad view of this. So we're not just talking about, the potential impact to, monetary impact. We're talking about broader physical or psychological harm that could be done to the individuals. It could include, impacts such as their inability to exercise their rights, or, being excluded from a service, or having even just a loss of control over their personal data. So really, when you're kind of interrogating this, you really need to be able to document in your legitimate interest assessments that you've thought about the impacts to the individuals, that you can show that you've taken steps to try and address and mitigate any risks that have been identified, and also that you're working through, as part of this assessment, some of the broader principles that the GDPR requires you to think through. So often this balancing test is effectively going to require that you look back and consider, principles like data minimization, transparency. Have you, explained to the individual how you're going to be processing their data and met your obligations to provide suitable notice to them? Is the data likely to be within their reasonable expectations? Or are you doing something particularly novel and new with potentially high risk outputs to the individuals, at which point you may not be able to rely on your legitimate interest, and the assessment might conclude that. So just taking kind of a step back and thinking, what are the types of questions we need to be working through when we're doing this balancing test? So thinking about the nature of the data, does it include any sensitive data? Because if it does, then again, we may not be able to rely on your legitimate interests. What's the nature of the relationship with the individuals? Do you have a direct relationship with them, which means it's more likely to be within their reasonable expectations that you'll be using data in the way that you're planning to, or are you removed from them? So you may need to do more to counter that issue. And then, is the processing likely to have a negative impact on the individual? So thinking through some of the other issues that I just spoke about, what kind of harm could result from this? Can you explain the data processing to the individuals? Are you able to explain how the model may work to generate the outputs? And can you give the individual any control over their processing activity? So often it's much easier to rely on your legitimate interests and meet this balancing test if you're able to give people not only transparency, but a level of choice over whether or not their information is processed for a particular purpose. So is there any ability to give them the option to opt out? So, and then finally, what other safeguards have you implemented to minimize any potential impact to the individual? So again, thinking through things like accuracy, are you testing the algorithms used are performing as intended? Are you prohibiting certain more sensitive data sets from being, used and processed in models? What steps are you taking to minimize potential bias? And how are you kind of taking steps to minimize the amount of information that you're processing to meet these particular purposes? Now, we know in the training phase of building out AI tools, you often need to use a vast amount of data, but not all data is good data. And so have you interrogated, is all of this data useful for the model training, or could we minimize it? Could we take steps to pseudonymize it even? So those are all things that you should be thinking through when you do the balancing test. Sorry, conscious of time. Next slide, please, Richard. So I mentioned in the beginning when I was doing the introduction that there are circumstances where the law is going to force you to rely on consent and you won't be able to rely on the non-consent based grounds like reliance on your legitimate interests. And that's really going to apply if you're doing things like processing any special category data or sensitive data through your, model training or deployment. So are you processing any data like biometric data for the purposes of uniquely identifying someone? For example, using facial recognition technology for authentication purposes? Are you processing any race or ethnic origin data? Now, in some cases, you may have collected the data for purposes that didn't involve processing or inferring sensitive categories, but through the AI processing, you might then, generate inferences or outputs that reflect sensitive data categories. And at that point, you would be processing sensitive personal data. So you need to keep track of both what happens when you're training the models, but also the outputs from that training exercise, or even through the deployment phase. Is it generating insights and inferences that could be sensitive personal data, at which point the GDPR requires that you typically process it in reliance on explicit consent. There are other grounds you can rely on, but typically it's very difficult to process sensitive personal data without having got the explicit consent of the individual. Equally, if you're doing any kind of automated decision making that has a significant effect or any kind of legal effect on the individual, and really we're talking about Article 22 of the GDPR at this point, then that's going to be very difficult to do that processing in the absence of explicit consent. There are some other legal grounds you could rely on, for example, that it's necessary to do that automated decision making to perform the contract. But in most cases, if you're doing that type of automated decision making, i.e. there's no human intervention in the processing, and the processing has a legal effect or significantly affects an individual, then you are going to be more likely than not forced into the explicit consent route. And we'll talk a little bit more about what constitutes automated decision making that falls within the scope of Article 22 in some of our future webinars. But you're really looking at legal effects like, outputs that would determine whether or not you can enter a country or not, determine whether or not you're suitable for a particular job, or whether or not, we need to cut off your electricity supply because you haven't paid your bills. If there's any type of automated processing that's done to generate those types of legal effects, then, again, we need to be very careful and consider whether or not explicit consent is going to be required there. It would also include things like automatic rejection of credit applications and such like. And then finally, some of the other examples where consent will be required is if you're doing any kind of tracking of individuals to collect information using things like cookies or other common tracking technologies, then we need to think not just about the GDPR, but e-privacy directive, and that requires that you get prior opt-in consent to do that tracking. So something to think about there. There are similar consent rules if you're trying to use precise location data. So, you know, GPS coordinates, lat long, all of that type of information can only usually be collected with consent. And the same, there are similar rules around processing communication content and metadata. That's all because of the requirements set out in the Privacy Directive. So again, very important to consider whether or not your processing involves any of these types of activities, because if you are, you know, tracking individuals, using precise location data, or doing automated decision making that falls within the scope of Article 22, you'll not be able to rely on your legitimate interests for some of that processing, and consent is going to be required. So a bit of a rush towards the end there, but just to say that we're going to be fleshing out some of the further concepts that we've talked about in this webinar, and some of the future webinars we'll be thinking about, you know, privacy by design and how to bake privacy into some of the development of your AI models. And then the next session, we're obviously going to be talking about ethics and explainability, which I think is going to be a very interesting topic that our colleagues Sergio and Andrea are going to be picking up on the 29th of April. We hope you enjoyed today's session. Feel free to ping Richard or I with any questions that you have. As we mentioned, the slides are going to be distributed to all attendees. But thank you very much for joining, and look forward to seeing you on future episodes of this webinar series. Have a good day.